Hey, everybody, and welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel. Like we try to do each and every Thursday night, doing our live Q&A. You're going to notice immediately things are a little bit different because I have a friend with me here. I got George Simons, co-founder of SoloSuit, who has been so kind to agree to join us today on the live stream to talk about all things debt related. I am an attorney in the state of Arizona. I help people with debt collection problems, bankruptcy, wage garnishments, all those kind of horrible things that are out there, and really just trying to find some solutions to it. And so what we do each and every Thursday night, I do this live stream where we talk about problems and questions that you all have. The way we do it is to go ahead and put them in the chat section. If you're on YouTube, if you're on Facebook, just put it in the comments. We'll put it up on the screen and talk about it. I wouldn't be any kind of lawyer if I didn't have some type of disclaimer. So my disclaimer is that while I am a licensed attorney in Arizona, I'm not licensed anywhere else. Take this for what it is, some guy talking on YouTube. If you need specific legal advice, I highly recommend you contact an attorney. And if you're in the state of Arizona, my information's below. I do free consultations for Arizona residents, and I can help you with your debt issues there. So with all that out of the way, I always talk about at the beginning how SoloSuit is one of the sponsors of our weekly live stream. So I'm excited to have George Simons on today, one of the co-founders of SoloSuit. George, how are you doing today?
Doing great. Thanks for having me on, John.
Yeah, no, I appreciate you being here and being able to kind of, I was thinking in leading up to this, how I got to know you initially. And it was really just being in this space of seeing people who are using kind of unique approaches to solving debt problems. The debt problems, particularly debt buyer and debt buyer lawsuits, I always say it's this kind of, even in the legal world, not a lot of people are aware of just the scope and extent of how these cases clog the courts and the kind of the damage they inflict on America, if I could say that. How did you get into it? I know you went to law school. I know that SoloSuit's not a law firm and you don't practice law, but tell me, how did you get involved in this field or this sphere of debt collection and debt buying and all that kind of stuff?
Yeah, for sure. Happy to share. So in my first year of law school, I bought a car that turned out to be a lemon. It died on me 3 days after I bought it. And I tried finding an attorney to help me get my money back, and I couldn't find one that would take my case. I thought, man, if I'm in a building full of lawyers and I can't find a lawyer to hire, who else out there can't find a lawyer to hire? Turns out lots of people can't. So I looked into the problem a little bit more, found out that debt collection lawsuits are the biggest category of cases in the US, and attorneys pretty much never take those cases because they haven't figured out how to do it profitably or at scale. So we made SoloSuit to do it in an affordable way for consumers, and people started using it ever since. So that's how we got started. I was lucky enough to use my newfound 1L legal skills to get all my money back in that situation. Also, worth noting, I was at BYU Law School. Go Cougars!
We got the Cougs there. Yeah, that's right.
Good season right now. So that's the origin story on SoloSuit.
That's awesome. So you're a law student, you go ahead and do it, and then that actually took you in a whole different direction where you're not practicing law, but you're running this company and building it. And you guys are nationwide, correct?
That's right. Yep, we're nationwide. Yep, and it's been growing ever since. We really try to do what people ask us to do for them, right? People will tell us, we want this feature, we want this thing added on. What we found out is that when people would use our product to respond to the lawsuit, usually they would want to settle the case as well. They're like, the desired outcome was to get the case settled. So we've since then created a debt settlement marketplace called SoloSettle, where consumers can make an offer to the collector to get the case settled. We bring the collector on board, they enter a structured negotiation, and then they can get a good resolution. And with that, we're really establishing ourselves as a trusted mediator between the collector and the consumer. So we recognize, the collector wants to get this case settled, consumer wants to get the case settled. So we're really just trying to move people towards a settlement in a very efficient fashion.
Yeah. It kind of goes back to the point you made. it is surprising. I hear it a lot here in Arizona where I practice, that people can't find someone to help them. And it's true. Even in the state of Arizona, I believe there's like 18,000 lawyers. I think there's like 3 of us that kind of do, particularly with defending people who are getting sued by creditors. And a lot of times it just doesn't make sense to get an attorney involved. I fully tell that to people up front that, look, lawyers are expensive. And even when we're trying to help consumers, it can be really difficult to make it economical. And so I know that's how I came upon SoloSuit. It's like, look, this is a solution where when there's people I can't help in particular, I send them over. I say, hey, look, here's some resources, and just having a plan of something you can do and going forward and saying, hey, there's something that may work for me, I think is a big peace of mind to people.
Right.
Let me, I actually there was a question on the channel that I wanted to bring up that I think is a good one. This one said, is it better to contact the debt collecting company or the attorney handling the case to try to offer money to settle? Thanks. So I know that you said that there's a settlement product that kind of makes it so you're not having to deal directly with the attorney or even the debt collector. You're kind of dealing with a platform where you both have access to it. Is that how it works?
That's right. Yeah, the platform connects like the consumer with the collector to get the case settled.
Yeah.
So this question here, is it better to contact the debt collecting company or the attorney to get a case settled? Right. So if you're being sued for a lawsuit, usually it's going to be better to contact the law firm that's suing you, so the attorney on the case. Kind of how that works is like if you're being sued by, let's say like Central Bank. You're being sued by like Central Bank, and then you have Smith Law Firm that's representing Central Bank. You're being sued by Central Bank, but you're also kind of being sued by Smith Law Firm. Smith Law Firm is effectively representing the bank at that point in time, so any communication about the lawsuit will go through the law firm. So you want to talk to the law firm and get the case settled. And so with SoloSettle, you can come on and basically tell us who the lawsuit's with. We'll make sure the information in your settlement offer gets to the right place, and then you'll be able to engage in the structured negotiation and get things resolved quickly.
Yeah, I get that question a lot. Well, I run into people a lot that say, "Look, I've got this lawsuit. They've sued me now. I don't want to deal with the attorney's office. I don't want to deal with trying to call the attorney or dealing with their paralegal staff or whatever it is. I'm just going to call the original creditor. I don't want to deal with the debt buyer." Yeah, and unfortunately, at that stage, you don't really have a choice. They reach out if it's been sold or if it's in litigation. If you call up Bank of America, they're going to say, "Hey, you're going to have to talk to our attorney now." So that can be, the tools that you guys put together there for settlement, I think, are good because it can be kind of intimidating to contact a debt collection law firm. People are always worried about, am I going to say something that's going to hurt me down the road? I do tell people in general, particularly if a lawsuit's been filed, most settlement discussions are not admissible. That the law firm's not going to be able to come and say, well, Johnny over here already agreed to pay X, Y, and Z as a settlement. Clearly they owe it. But I can see how that could be a good tool to eliminate some of the confrontation that people are anticipating might be, in place if they're reaching out to a debt collector. So let me jump into a couple more questions that we had here. This one I thought was from the channel. I thought it was kind of made me smile a little bit. And it says, crazy to me that someone would go through all this for $1,500. As far as debt collection lawsuits, I know you see, I deal with people here in Arizona. You see things more even on a national scale. Do you see a lot of people that hire SoloSuit where they're dealing with things like this, $1,500 lawsuits? I mean, I've even seen them lower than that. But what do you see on a nationwide schedule or perspective on that?
Yeah, we see a broad range. On average, debts that come to us are about $4,700. The range is very broad. We've seen some for around $100. I don't know if we've seen anything less than $100.
Oh, wow.
Oh, we have. But we've seen as about as low as 100. And also we've had people come to us for hundreds of thousands of dollars, usually regarding mortgage debts.
Yeah.
Yep.
Yeah, I think the lowest I've seen is a $500 lawsuit. And, something that I once had a collection attorney tell me is he said, look, no one's going to file bankruptcy over a $2,500 lawsuit, but they do file bankruptcy over $60,000 lawsuits. And so, at least where I practice, they say, look, we'll file a lot more of these, what they consider lower level lawsuits, as opposed to maybe some of these 50, 60, 100 grand credit cards that are out there, which is backwards from what you might think. Alex Chavez down in Yuma, Alex, regular on the channel, says, are many creditors or collectors agreeing to use the SoloSettle platform? How does that work? Does the creditor have to agree to it, or how's that going to be in place, or how does someone know if they'll be able to use it?
Yeah, really, so SoloSettle is set up in a way that the collector doesn't need to opt in or sign up to use it. They'll basically like receive a message to engage with the settlement offer from the consumer. So no matter how big or small the collector is, they can be brought onto SoloSettle. So even if it's like sometimes there's law firms that just happen to be taking this case for like a client of theirs, like they aren't necessarily regular debt collection law firms, and they can be brought onto the platform. And then also there's folks like the biggest creditors and collectors in the U.S. that are using the platform regularly, right? Like Midland Funding or any of the large banks.
Okay, awesome. We had a question here. Said, quick question. In Kansas, where I live, they say creditors can't collect a debt after 6 years. So we're talking statute of limitations here. How can I check to see if my debt is past 6 years? I think this coming year marks 6 years. I can tell you, this is the question. this is what lawsuits are fought over often, is that date. As far as when does the clock start ticking? And a good general rule is when one party can sue another, the clock starts ticking. And so, there's no database, there's nothing you can look at and say, okay, there's your date kind of thing. But it's something where I always say, if you look at the terms and conditions on a credit card agreement, it's usually 30 days after you miss a payment. Technically, they could sue you. They don't, but technically they could. I always see, sometimes I see debt collectors, they try to argue it's a charge off, which is usually 6 months after the payment stops. But it's that kind of gray area where sometimes you have to make that argument. Do you ever see issues like that pop up with statute of limitations, George?
Yeah, it's a good point. A good summary of statute of limitations generally, that once one party can sue the other party, the clock starts ticking, right? So in these cases, it's generally from the day that the consumer made the last payment, essentially, right? Or when they essentially first defaulted on the debt. That sounds about right to me. We have a statute of limitations calculator on SoloSuit.com that you can check out. That you can punch in like the day you made a payment last in Kansas, and then it will calculate when the expiration date is in Kansas.
Awesome. Maybe I'll see if I can get a link to that, and we can throw that in the chat section. Let's jump into this one here. Carpe Diem says, recently I received a debt validation letter for the same debt in Texas for a case that a non-suit had been filed and accepted in Virginia. I disputed it. I then sent the same documentation used in the Virginia case, this time from a different law office. I'm now wondering if they'll pursue legal action again and if I can cite res judicata to defend it, given that it was closed with prejudice. This is a well-versed watch. We got the Latin coming out tonight with the res judicata.
I guess the name's Carpe Diem. Should have known that you did it with the Latin.
Yeah, there should be no surprise there at all on that. So, and this is interesting because I actually have a case that I'm dealing with right now. It's a new case where they filed a lawsuit in Arizona, and this whole statute of limitations issue come up because they actually had filed the lawsuit previously in New Mexico and then agreed to it was dismissed for lack of prosecution. And then the client moved to Arizona, and they refiled it. And so the legal issue there is because it was an installment contract. And now we're getting into the weeds of this, but the legal issue was the loan accelerated when the New Mexico lawsuit was filed, and thus triggering the statute of limitations. And now it would be time barred in the state of Arizona. So it's interesting because it's kind of you'll see this. And I think to the point of Carpe Diem, sometimes different law firms will use, they don't, right hand doesn't know what left hand is doing. The company will use a different law firm in different states to handle it, and they may not even be aware of it. Now, they talked about the debt validation process. I know you guys have a tool that helps people to do that. Explain a little bit how that works.
Yeah. So in this situation, the consumer Carpe Diem saying that they received a letter validating a debt, right? So I think did they send a letter requesting validation?
That's what I'm not clear. I know so SoloSuit has a product where you can actually, the consumer can reach out to validate it.
Yep. So SoloSuit, you can request validation of the debt. Right under the FTCPA, you're allowed to request validation of a debt if the validation isn't provided when a collector contacts you at first. Currently, for people who are coming to us to settle on our platform, we aren't necessarily encouraging that they use the debt validation letter. We're finding that it's best if they file an answer. Well, if they are pre-lawsuit, we recommend usually just making an offer to settle, rather than trying to throw like a wrench into the situation with a debt validation letter. If you feel like you owe the debt, right? If you have like no idea what this debt is, or like you don't owe the debt, certainly go ahead and go for a debt validation letter. But if it is your debt, if you recognize it, probably the quickest thing to do is just going to be to make an offer to settle. And then if you are being sued, you just want to file an answer document. The debt validation letter isn't really something for you at that point in time.
Maybe just expand on that a little bit as far as the debt validation letter kind of throwing a wrench into things. I see this a lot where people will do the debt validation letter, and it can be very helpful as far as getting information. But what do you mean by that as far as maybe throwing a wrench into the whole system?
Yeah, I think there's lots of different strategies, right? I think maybe for a lawyer representing somebody, maybe doing like a debt validation letter is a great move towards resolving the case. For us, what we see is that if a consumer is in collections and they haven't been sued for the debt yet, if they send a debt validation letter to the collector will mark the account as disputed, and then they will stop any action on the account, usually for like a month or more, and they will try to make sure all of their boxes are checked, make sure all of their T's are crossed, their I's are dotted, and make sure that they have the right information for the debt, that they have the right to collect on the debt. And that can really delay the process. So if you send the debt validation letter to a collector, and then try to settle, the collector won't respond to you. So the collector won't respond to you until after they've actually validated the debt themselves and made sure that everything's good to go. So it will delay the settlement process. So if you want to get the case settled, it's probably going to be best just to make an offer to settle.
Yeah, no, I see that. And that's what people don't understand. Like you were saying, they send the letter, and under the Fair Debt Collection Practices Act, they can't, really kind of move the whole process forward until they've sent you the information that you're requesting, essentially. And so, and it's also a timing, with validating a debt. I see a lot of people want to try to validate the debt after they've been served with the summons and complaint. At that point, you can send the letter and they'll send you information, but that doesn't stop the time period as far as you having to respond to it. And so it's important to make sure you do that. Now, I know probably the thing that you guys were known for right from the get-go was helping people to file answers to lawsuits. The last statistics I saw, and granted, it was one of these books here behind me, so it was older, is like 95% of people who get sued by debt collectors don't file answers. Is that your experience as well, or what are your thoughts there?
Yeah, I'd like to think we've been moving the needle a little bit more towards helping people actually respond to the lawsuits. but certainly the going number is around 90% don't succeed in actually like filing a response.
Yeah. And I always say just filing the answer, just submitting that answer opens up so many more options. And that's the problem with most of these default judgments, is that if the default's entered, it closes off a lot of things. It may put you in a much more difficult position to settle. You don't have as much leverage as you do if you're filing an answer. It buys time, it buys the ability to negotiate, it buys a lot of different things. You can look at arbitration, all these other different types of things to get a better settlement in place. And it really goes to, some people are like, they're gearing up for a fight, and maybe I was thinking maybe it's my YouTube channel that influences people on that. I always say you have to define what a win is. There are ways to, contest these different lawsuits, but very few of them actually go to trial, at least not with me. I don't take a lot to trial because sometimes the best win is just a settlement. It's a quick settlement. It's maybe not sending in the validation letter like you were saying. It's just getting this thing out of your life, because one thing that people I have found that are representing themselves is it takes over your entire life. You go to work all day and you come home at night and you're dealing with all this stuff, or sometimes just getting the case settled on fair terms and making sure that it's done correctly. I think that's one thing, whether it's an attorney or SoloSuit, in trying to negotiate a settlement, is you're going to get something in writing to be able to confirm the terms so that it's not just this open-ended thing. So,
right.
Let's see here. We had a question here from Doug. So, can I file a motion to dismiss for lack of prosecution if there's been no activity on a debt lawsuit against me for over 6 months after I filed an answer? The answer to all these things is yes. You can file. The question is, will it be granted? And a motion to dismiss for lack of prosecution depends on the jurisdiction you're in. Here in Arizona, I can say that like cases under $10,000, they're dealt with in our justice court system. The case is supposed to go to trial within the first 10 months, which seems like an insane amount of time for it to go by, but that's actually really slow. The wheels of justice move slowly in civil cases in most jurisdictions. In Arizona, cases over $10,000, they're filed in the Superior Court. The average time from lawsuit to trial is usually 18 to 24 months. Simpler cases can go more quickly, but it's at least a year. And so it'll depend on your court. But yeah, if the case has just been sitting there, if they're not doing discovery, if they're not, filing disclosures, if they're not doing anything to push the case along, I'd file a motion to dismiss. I've done that recently. I had one last month where the case has sat there forever. The creditor wasn't doing anything, and I moved to dismiss it. That's another way I have found to get kind of maybe a good settlement. Even if dismissal isn't granted, the attorney may be more motivated just to get this thing squared away. So,
right. Yeah, that's a good move for settlement, right? Because even if the case gets dismissed, if you owe the debt, they can still come after you outside of court. They could also, if it doesn't get dismissed with prejudice, they can sue you again for the lawsuit for the debt. So if you feel like you owe some portion of the debt, right, you can use this to leverage a settlement and get it fully resolved.
Yeah, and it's a good point you bring up. Is I typically see when cases are dismissed for failure to prosecute, unless it's pretty egregious, the courts will often dismiss without prejudice in those type of situation. Meaning, if the statute of limitations is not expired, they can refile it, or they may even be able to just ask you to voluntarily pay it, even if it's been dismissed for failure to prosecute. So, a couple things to think about there. I was thinking about with that validation. We had this quote on the channel. Said, "What do you do if you're threatened to be sued by a company that clearly has made up the debt?" This is probably a situation where maybe a validation letter or something like that, where you're trying to get more information about who they are or what they're doing, may be a good approach there. So,
yeah, right. Yeah, debt validation letter in this case, right? If you don't owe the debt, send them a debt validation letter. If you feel like the company itself is fraudulent, right, you can always file like FTC complaint against them, report them to the CFPB, the Consumer Financial Protection Bureau, and try to take further action like that. If they're coming after you for like a fake debt, they're probably more likely also to violate the FDCPA. So you can also potentially sue them for violation of the FDCPA. And if this is a case, like this probably isn't a reputable debt collector, right? Like the large debt collectors and banks, they're very cautious. They make sure that they're doing things properly. They spend lots of money and lots of time being compliant. So if you have a situation like this, it could just be more of a scam, or just like a guy with a spreadsheet that's like bothering you at night to pay him money. And in those cases, you can take further action to kind of protect yourself here.
Yeah. Yeah. And those exist. I early in my career, I ran into, it was somebody who was sending out just these egregious collection letters, like saying, hey, we're going to come and arrest you. We're going to, all this kind of stuff that was just totally out of bounds. And, I filed an FDCPA lawsuit alleging, they had violated it, but I found it was something like that. Literally their office closed down, and just the guy was an attorney who was running it. And he even told me, he's like, you don't understand how this works. We'll just close down and reopen up under a different name. And I was like shocked that, this lawyer is saying this out loud to me, but it does. There are some bad actors out there for sure. But a debt validation letter can at least be one step to make, to double check. Cause I run into people every day here in Arizona that say, look, I don't even know who this company is, particularly if they're dealing with like a junk debt buyer, which makes sense because you didn't borrow money from them. They didn't loan you money. So you don't even know who they are. And it can give you a better sense of where it's at. So, all right. I think maybe we'll kind of wrap that up. That's about a half an hour. George, I put a link to SoloSuit here in the chat section. People can go there. All the tools for SoloSuit, go there, check out their website. A lot of awesome tools to help people. It's the main thing I always say is having a plan is what's going to alleviate some of the stress. It's just that anxiety of the unknown, thinking that you're going to go to jail kind of thing. There's no jail, but it is important to have a plan. And this is just one of the great tools out there that I think can help you, particularly if it doesn't make sense to bring on an attorney like myself. It's worth going there to check that out. But George, I appreciate you joining us today and all you've done. And with that, I think we'll check everybody out next week. We'll talk to you later.
Thank you.